Good morning. Thanks for joining us for this installment of the Pro Bono Partnership of Atlanta's monthly webcast series. Today, we're going to be talking about who is responsible, the legal pitfalls when working with PEOs or payroll processing companies. My name is Sarisha Gunta. I'm Counsel and Education Director with PBPA. And today we have Josh Joel with us to speak to us on this topic. Josh is counsel at Stanton Law here in Atlanta, where he advises small and medium-sized businesses on employment matters. He's also host of his own podcast called Been There, Do This, and he has even been a guest on our own PBPA podcast. We're excited to have Josh speak to us today. Before Josh talks about the substance of today's presentation, I want to take this opportunity to share with our audience a little bit of background on PBPA. Our mission at PBPA is to provide free legal assistance to community-based nonprofits that serve low-income or disadvantaged individuals. The way we're able to achieve this mission is by matching those grassroots organizations with law firm and in-house attorneys here in Atlanta. Our clients are all 501c organizations, primarily serving or based in the Atlanta metro area that serve low-income or disadvantaged individuals and are otherwise unable to afford legal services. If you're interested in applying to be a client with PBPA, please go to our website and fill out a request for legal assistance. Also on our website, we have resources that are available to any nonprofit that's interested. These resources include articles, webcasts, podcasts, and events for upcoming, or a calendar for upcoming events. Please check out our website for those resources. And finally, a quick note, please keep in mind that the information that Josh is going to be sharing with us today is just general information. It is not legal counsel. It is not specific to your organization. So if you do have specific questions, please be sure to reach out to an attorney. Josh will be taking questions during the course of today's discussion. So feel free to type this up in the chat. This is for our live audience, but please remember to keep those questions pretty general. And now I'll turn the mic over to Josh.
All right, well, good morning, everyone who's here and those who are listening after the fact to the recording. It's always a pleasure to be here with the Pro Bono Partnership of Atlanta and to support all the work, Sarisha, that you guys do helping out nonprofits. And it's a real passion of mine is to make sure that we're providing the best legal services to everyone, a for-profit, nonprofit, and really bringing that to the city of Atlanta. So really excited to be here as always and to be a part of this awesome organization. As mentioned, I'll go through quickly the agenda of what we're going to talk about today. And if anybody has any specific questions with anything that comes up, you're welcome to drop it in the chat and either we'll answer them on the spot or towards the end of the program. And so what are we talking about today? Well, PEOs, payroll processors, and something called an EOR, which is something that a lot of people don't know about, and some of the legal issues that come up when you're dealing and working with these folks. And most small, mid-sized businesses don't necessarily have the wherewithal to do a lot of their HR compliance on their own, and therefore they reach outside kind of to outsource that either to a PEO and a professional employer organization, I believe is what it stands for, and a payroll processors to run the payroll system. And so oftentimes we see in my practice as an employment lawyer, mistakes that people make when they're dealing with these folks, because oftentimes as a general principle, when they try to buy your business, they talk about how they're going to take care of a lot of your legal compliance and a lot of and help you deal and make sure that you are compliant with the various tax laws, employment laws, and other things like that. And in reality, sometimes it doesn't pan out that way, and business owners can get into trouble if they put too much reliance on the PEOs, the payroll processors, or the EORs in some circumstances to take care of that. So we're gonna talk about that today and give some practical advice and practical studies or case studies or examples of things that I see in my practice of mistakes that business owners make. But before we do that, just to walk through what we're going to talk about, I'll give you a general outline of what PEOs are, payroll processors are, EORs are, and what the differences are. We're also going to talk a little bit about some of the main issues, the main legal issues or legal concepts that apply to this, and then we're going to go into some more practical examples and practical advice with respect to those issues, both with respect to taxes, employment liabilities, talking about discrimination, these kind of things. Most importantly, in terms of the mistakes that we see issues under the Fair Labor Standards Act, which is the wage and hour rules, which applies even to small employers, and talk about how to resolve those issues, and then give some practical suggestions at the end. So we'll start with just a general, some general education on who are these people, the word salad or the letter salad of PEOs, EORs, payroll processors. What are we talking about over here? And so I know a lot of people probably know this. This is the ABCs, the basics, but may as well throw it out there to make sure we all understand. So payroll processing company, y'all probably hear about ADP and Paychex and these folks. Some of them do actually, those companies do provide some PEO services as well, but at their core, they're just basically payroll companies. They manage your payroll, not much more. They don't do much more in terms of HR compliance and other things like that. And as time has gone on, a lot of the payroll processing companies that traditionally only did payroll processing are taking on more and more PEO type functions, HR type functions, which we'll talk about in a moment. And that's important to know because where the legal issues come up often lies in the gray area between how much are they actually taking on for you and how much responsibility are they taking on with respect to the employment liabilities and the HR compliance issues, as well as the tax compliance issues. So payroll processing companies, generally the issues there, which we'll talk about, are going to be making sure that they are compliant, making sure that the tax compliance is appropriate withholdings are taken, and they're taking care of your essentially your tax compliance when it comes to your employees, and not much more. But as you start to morph into a more professional employer organization or a payroll company doing more HR type roles, then we start talking about additional issues that come up that we tend to rely on the PEOs to take care of those issues, and sometimes that might not be the best idea. And so what are the kind of things that PEOs take on? And there are many different models, and we'll talk about how to know who your PEO is and what they're taking on. But essentially, some of them take on a completely and totally outsourced human resources type role, because many small companies and nonprofits and small businesses, the person running the HR is generally going to be the CEO, the COO, the founder, the owner of the company. And let's face it, they're not necessarily trained in human resources. They're not trained in employment law. They're not trained in the things they need to do and they're forced. And I see it very often in my practice, especially with small businesses and nonprofits. They're forced into a role that they're not necessarily comfortable with, dealing with day-to-day human resources issues that the founders and the business owners are not necessarily equipped to know how to handle. And so therefore, they'll often call me as an employment lawyer to work them through some of the basic human resources issues. And one of the things I often tell these small businesses, we're talking about 3, 4, 5, 15 employees, when I keep getting questions. In fact, right after this webcast, I have a call with a small business owner talking about the termination of a staff member. And the reality is a lot of that stuff doesn't have to be escalated to the level of an employment lawyer, where you have to go pay lawyers' fees and legal fees to deal with day-to-day HR issues. So number one, obviously, small business owners need to train themselves on some of these HR issues. But to the extent that they don't have the time or don't have the will to do so, that's where the PEOs sometimes can come in and help with some of the basic human resources functions that a small business owner or nonprofit doesn't necessarily know how to do. So obviously the most basic is going to be similar to the payroll processing companies, dealing with withholdings and payroll and tax issues, making sure your payroll is going to be done properly. Then they start expanding into areas of providing benefits, even health insurance and other things like that, where you can tap into a broader health insurance pool or other benefits to be able to have that as well. Some PEOs provide that. Some PEOs provide more robust human resources functions, where they'll come in and they help you with your employee handbooks, they'll help you with your employment policies, and some will even help you troubleshoot certain human resources issues that come up, such as complaints in the workplace, and provide you really what's more of a human resources consulting role or an outside HR consultant. And some of them even consider themselves kind of fractional HR directors for small to mid-sized businesses. So there's a wide range of PEOs. There are also PEOs that provide staffing services. And so the term PEO is actually very broad. And we're going to talk about how to know what they're doing and who you're dealing with and why and what they need to know. And of course, regulatory compliance, tax administration, that's some of the basics. But how does it work? What's the basic structure before we get to the payroll processing companies? The basic structure of the PEO is that they set it up that I have an employee and I set up what we call a co-employment relationship with the PEO, where the PEO becomes like the employer of record for tax purposes. And so the W-2s and the tax compliance and withholdings with the IRS are generally going to be handled by the PEO, and it's as if they're the employer for the purposes of taxes, but it's actually a co-employment relationship where imagine the employee is essentially employed in different aspects by both the company and the PEO. And we're going to talk about what that means and how that affects various liabilities that you have. Okay, so that's the basics of PEOs. I want to touch a little bit on some of the issues that we see with payroll processing companies, and I'm going to touch on it very, very basically. And the general principle that if there's one takeaway that I want everyone to hear when they listen to this webcast today, and I'm going to come back to this over and over and over again. Do not rely on your payroll processing company, your PEO, or your EOR, which we're going to talk about, to do all of your legal compliance. Do not rely on them. Oftentimes, the PEO or the payroll processing company, their sales pitch to the business is going to be, we're going to take care of all your legal compliance. That may be true, but that doesn't mean that they take on the legal liability for doing so. And so when we talk about a payroll processing company processing your payroll, processing your taxes, processing your withholdings, reporting things to the IRS, a lot of business owners think that they can just wash their hands of it. They don't have to worry about it because the payroll processing company is taking care of it for me, so I don't need to think about it. The reality is that the legal obligation still rests on the business to make sure things are being done right. And you need to back check and make sure that your payroll and choose your payroll processing company, choose your partner within a payroll processing company to the extent you have a representative who you have a relationship with, depending on the size of that payroll processing company, that will be able to work with you to make sure that these things are being done right. Because even though the payroll processing company may mess up and they may not do it exactly right, they have a large volume, the business is still going to be on the hook potentially for the lack of compliance in those areas. And therefore, it's important to make sure it's being done right and back check it and back check the documents and make sure things and be educated on what needs to be done, and just don't wash yourselves of the issues and hand it over to the payroll processing company. And if it comes up that something that you get a notice from the IRS or you get a notice from any other regulatory agency about something that's going wrong with your tax compliance, your withholdings, that's your responsibility. You need to take care of it right away. You obviously want to work with your payroll processing company to make sure that's done right. But at the end of the day, you have to recognize the responsibilities on you in many, many ways. The payroll processing companies are enormous, and they're obviously going to look out for their best interests first. And when it comes to a lot of these issues, they're not necessarily going to flag or flag you any of the issues that come up with compliance. And therefore, if you get a notice or you get some inclination or some inkling that something's going wrong, the responsibility is on you to go to your payroll processing company and deal with it and resolve it. So that's the main point that I want to make with the payroll processing companies, and then we'll move a little bit more into the PEOs and the EORs and the difference between them. If you can just advance the slide, that would be great. And to the next one. So I wanted to touch on this concept of an employer of record, and I'm going to do it briefly because it's not as relevant to a lot of people, but I'm seeing as the world is getting smaller and smaller, even for small companies. I've got clients that have 3 or 4 employees who are all over the country. And we're not in a world anymore where we have to be limited to our local talent pool. And we've been able to expand our talent pool, frankly, all over the world. And so there's this concept called an EOR, which is called an employer of record. And that's a little bit different than a PEO. It's actually a lot different than a PEO from a legal standpoint, because when you deal with an EOR, which a lot of people don't know about, they become the employee's full legal employer. The employee is no longer employed by you from a legal standpoint at all. Now, you're managing the day-to-day operations of that employee's work, but the actual employment contract, the employment relationship, is with the EOR instead of your company. And they handle pretty much all the administrative work, even though day-to-day the employee is working for the company. The advantage of this is that by doing that, all the liabilities do rest on the EOR and not on the PEO, or not in the company, which is different than a PEO. And this is very popular with small companies that have a national or international labor pools. They want to hire people in different states. We're here based in Atlanta, but I've got clients that have 3 or 4 employees, 2 of which are in Colombia and Argentina. I've got clients here in Atlanta now that the world is getting smaller, especially with the remote and hybrid work, who want to hire people in Ohio and Utah and Tennessee, in California, in New York. And we don't have the wherewithal as a small business to know how to do that. One answer to that potentially is an employer of record, where you hire a company to employ your employees for you, and they take care of all the tax and legal compliance in every jurisdiction where a person wants to hire an employee. And there are some advantages to doing so. So I wanted to bring your awareness to this possibility if you do plan on hiring multiple employees outside the state of Georgia. So we can move to the next slide as well. The differences between an EOR and a PEO, and I'm not making a sales pitch for one or the other, I got no skin in that game. But to understand is basically an EOR is you're outsourcing your employees much more so than with a PEO. So PEO, they're going to have certain requirements to have a certain number of employees, staff there. They're going to require you to bring all your employees into the PEO. They're going to when you have that, you yourself, or since you're the employer, are going to be registered in each state where you do business. And unemployment workers' comp, since you're the employer, is generally going to be on you. When you deal with an and the legal liabilities are often shared between the PEO as a co-employer of the employee with the business owner. If you move to the more robust EOR model, they really do a lot more than that, and they give you a lot more flexibility to hire 1 or 2 people in different jurisdictions and different states, and you don't have to be registered there. You don't have to have a corporate presence there because you're not actually the employer. And then they take care of everything. It's as if that employee does not work for you, even though you do the day-to-day functions. It's just something to be aware of as you're thinking about who you want to engage, whether a payroll processing company, a PEO, or an EOR. And there's obviously risks and benefits to each one. But an EOR is going to be more appropriate for smaller companies that want maximum flexibility, less lengthy terms of service with their employees, and just want to have someone in a different state work for them and don't want to deal with a lot of the legal compliance issues. All right, so we'll move forward to the next slide. So now we're going to talk a little bit about, now that we understand what actually is a payroll processing company, a PEO, and an EOR, we're going to put the payroll processing companies aside. We talked about that a little bit. We're going to, and the EOR aside, because that is the further extreme. Let's talk about the middle gray zone, which is the PEO. Single biggest issue that you need to be aware of when you're dealing with a PEO is understanding the law as to who actually is the employer of that employee. And why does it matter? Because the employer is going to be the one who's responsible for compliance with all the laws and the rules and the regulations. And the employer is also going to be liable potentially for actions of the employees. So a classic example, this is a case that came out of the Southern District of Ohio in 2019, which is just so classic of what happened. The CEO testified there was issues of FLSA compliance, wage and hour compliance. They were not paying overtime correctly, and they had relied on the PEO to take care of the overtime issues and take care of their compliance. And the PEO test, and this is so normal for a CEO to say this from a business perspective, but recognize what this means from a legal perspective. The CEO of the company said, I hired the PEO to take care of everything I needed, and I didn't think anything else about it. And the PEO there were certain things that were done incorrectly with respect to overtime and wage and hour compliance. And they came back and sued the company, the CEO and his business. And when the CEO came out and testified to the fact, either in deposition or at trial, I don't recall which, that he didn't even think about it because he just dumped it on the PEO to deal with, the court and the rule that was actually an admission of negligence. It was negligent on the part of the CEO just to rely on a PEO to do everything for him, and therefore held the CEO and the company responsible for that overtime compensation. Double damages, in that case, it was over $500,000. Double damages because it was considered purposeful and negligent that the CEO just relied on the PEO to do everything for him and did not back check it, did not consider his role and his responsibility to provide the appropriate information and the appropriate guidance to the PEO with respect to what he needed to be done, and therefore he was individually liable. So that's an extreme example, but it's actually very common, and it represents and illustrates how important it is for a company that employs a PEO to recognize that you can't just, yes, you can offload some of the compliance issues from a practical perspective, but from a liability perspective, you're often going to be on the hook because you are still often the employer of that employee in most situations. So we'll move on to the next slide. So the different laws, and this gets a little confusing, so I don't want to get too deep into it, but the different laws, federal laws and state laws, treat these situations a little bit different. And there are different legal tests to determine who is the employer and who's going to be responsible for it. And I put a lot of information on the slide so people can come back and look and have it in front of them. I'm not going to go through all of it. But when it comes to the key point, when it comes to IRS and taxes, coming to tax compliance, withholdings, making sure you're doing that, the PEO is considered practically the employer for tax liability and compliance, and there really is no such thing as a co-employer in the IRS tax code. It's really, they just view it as one employer, and that's going to be if the PEO handles all the aspects of the payrolls and payroll filing, payrolls and tax filings and everything else. Generally, the PEO, and it's all done under the PEO's EIN. Generally, the PEO is going to be considered the employer, period, of the employees for the purposes of tax compliance. But at the end of the day, when it comes to legal issues, the employer needs to know and understand who he's working with and make sure that the PEO that he's working with is appropriately handling all the issues, because some things can come back to hurt the employer themselves. Recently, the IRS, in the last couple of years, in order to deal with the issue and the proliferation, I don't know if that's a word, of PEOs and their involvement in the industry and really becoming a major player, especially for small to mid-sized businesses, they launched a program called the Voluntary Certification Program for Professional Employer Organizations. And essentially, PEOs have the opportunity to become certified by the IRS, and there's a typo in my slide over here, but you're not off the hook, you're off the hook. I don't know what a hook is, but anyway, if you hire an IRS certified PEO, you're actually off the hook for almost any liabilities if the PEO fails to fulfill its obligations to remit taxes or file taxes on your behalf. It's almost like an immunity. That if the PEO has become certified by the IRS and is on the list of the voluntarily certified PEOs with the IRS, I think they call it I don't know, they have a name for it. But if you do that, and I would recommend that, then you're actually off the hook for liabilities if the taxes are not filed. And so therefore, when you're looking at PEOs, it's really important to consider whether or not the vendor that you're using is certified by the IRS as a PEO that has been, and that would save you a lot of time and a lot of heartache if mistakes are made. And so, all right, let's continue to the next slide.
Josh?
Yes.
We have a question from the audience that
Yes.
wanted to see if you had any thoughts on this. They're asking about the Small Business Efficiency Act, and they're wondering if you see the Small Business Efficiency Act upheld in a court of law when it comes to liability for FLSA and wage and hour, and how that would affect nonprofits.
Yeah, I think I'll address some of that when we get to in more detail the FLSA, and that's something that I want to talk about with a little more practically, if that's okay. So and the short answer is that I don't think it's making a huge difference right now, but we'll talk about that momentarily. I did want to discuss briefly also about issues of discrimination, ERISA, which I don't really want to get into because it's boring and complicated. But when it comes to issues of employment liabilities, referring to things like who's responsible if a manager is discriminating or harassing someone else, over here, there's a common law standard in terms of who's the actual employer. And this is unlike the tax compliance and the IRS. It's a little different when it comes to FLSA, to Title VII, which is discrimination laws. In these situations, it is possible that multiple individuals or multiple companies can be liable or can be found to be the employer, co-employers. This is more common with staffing, less common with PEOs. But to be aware that it boils down primarily to issues of control. Who controls the day-to-day actions of the employee? In this situation, the PEO is not generally considered the employer unless the PEO performs or has the authority to perform more than just the payroll processing and benefits administration function. Meaning, the more that the PEO takes control of the day-to-day activities of the employee, which is generally not the case because they're smart enough not to do that, the business is going to be on the hook for liabilities when it comes to the employees. Now, as PEOs have expanded and grown in terms of the offerings that they give, the PEOs are finding themselves in the hot seat sometimes because there are certain states that are giving the PEOs greater liabilities for different types of employment actions and employment liabilities. And the PEOs are trying to be very careful in how they carve out their relationships, not to be considered the employer and be on the hook for example, a discrimination claim. There was a case out of New Jersey recently where the PEO was found to, and a nonprofit, were both found to be the employers, at least for the purpose of surviving summary judgment. The court did not dismiss the PEO. I think it might have been ADP. I don't recall which one, but the court did not dismiss one of the big players as an employer outright, because they said it was as a matter of fact as to whether or not the PEO is going to be considered a co-employer to be on the hook for certain employment liabilities. So that's something to bear in mind. I'm not going to go into the specific control factors, but bear in mind, because it gets complicated, that generally you are responsible for these issues. And sometimes the PEOs, as part of their benefit to you, they'll tell you that they have employer practice liability insurance, EPLI insurance. It's going to be important, as we'll discuss later, to make sure that you understand the limitations of the EPLI coverage that the PEO provides and whether they will cover causes of action that are brought against the company itself. Okay. So moving on, again, I just put this on here so people can have a sense later on if they want to look back at the slides. The common law right to control test when it comes to employer, it basically boils down to financial control, behavioral control, and the relationship of the parties, which generally is going to bend in favor of the company being found to be the employer when it comes to these kinds of employment liabilities. All right. Let's talk about the FLSA, the Fair Labor Standards Act. Before this program, Suresh and I were talking about how this has been a bit of a ping pong back and forth over the last couple of years, and I'm sure you all have heard quite a bit about this. But between the Trump administration towards the end and then pinging back to the Biden administration, what is the test and how do we know who is the employer with respect to the Fair Labor Standards Act? And for those of you, I'm sure you're aware, the Fair Labor Standards Act are the wage and hour rules, the overtime minimum wage. And the test now, without getting into the history and the politics of it, the test of the Department of Labor is applying right now, and this might change if this swings back to another Republican administration. We don't know. This is a controversial issue, is whether as a matter of economic reality, the worker is reliant on the hiring party to earn a living or is self-reliant like an independent contractor. And so there are different factors to consider as to who's going to be responsible for the liabilities under wage and hour rules with respect to the Fair Labor Standards Act. Now, it doesn't matter what your agreement is with your employees. What matters is what is the reality on the ground. And so under this test, because of the economic realities, without the extent to which the employee is essentially reliant on the hiring party to earn a living, and there's factors in how to consider that, you need to be aware that under the Fair Labor Standards Act, generally, the business owner is responsible for wage and hour compliance. The business owner, this is the general rule, and this is the assumption that you should make. The business owner is going to be responsible for wage and hour compliance. The business owner is going to be responsible for a failure to pay overtime. The business owner is going to be responsible for a failure to pay minimum wage or to keep the appropriate records with doing that, because the FLSA has record keeping requirements. And so oftentimes the PEO is not going to be responsible, while they are going to be the ones who are administering the compliance with these areas, they're not going to be the ones responsible, or they're not going to be the only ones responsible for your wage and hour compliance, because the economic realities are such that the employer really looks like an employee of the company as opposed to PEO, which is just administering benefits or doing the actual paperwork in many situations. So it doesn't really matter what the PEO says or the payroll processing company says. A lot of times they'll say, we're going to take care of your wage and hour compliance. And as we saw with the CEO before, the business owner relies on that in order to be able to do their overtime calculations and these things like that. But in reality, they get caught holding the short end of the stick when a disgruntled employee leaves or an employee gets wind of the fact that things are not being done right. And we'll explain right now what that is, because this is the single biggest issue that I see in my practice with respect to PEOs. You can move to the next slide.
Josh, I have a quick question
Sure.
about that on the last. So if a nonprofit had a signed agreement with the payroll provider or the PEO that states in it that the PEO is the employer, if that's in the contract, is that not sufficient to make them responsible for wage and hour? Considering,
no.
Okay.
Short answer is no. The agreement doesn't matter. What
Okay.
matters is the economic realities of the relationship between the employee and the employer. In fact, that's one of the big mistakes. And I know there are probably some PEO people and ADP people or payroll processing people might be listening to this. So I hate to throw you under the bus, but the reality is unfortunately, as I've seen in my practice, when it comes to the sales process and it comes to the compliance process, I'm going to be careful how I say this. The companies make guarantees or make promises. They're going to make sure that things are going to be done right. And we're going to be the employer. We're going to take care of this all for you. And therefore, the CEOs or the founders, the nonprofit executive director or HR director thinks they can wash themselves of the issue. And then when a problem comes up, and I hate to say this, oftentimes the payroll processing company or the PEO shows you the small print in their agreements that you didn't read, which shows that they don't have an obligation to indemnify you for those claims, that they don't have and oftentimes and they don't take responsibility for the issues and kind of leave you hanging around these things. And I hate to say, but it's the reality of what I see. And so what happens, especially very common, is that and I'll show you in a moment a real world example of this. But what happens very commonly is that there's mistakes or problems on the record keeping, which land the business owner in trouble. And when a lawsuit comes up, a plaintiff's attorney comes up and shows those issues and sends a demand letter, what I get is that an angry, very often this happens probably, I don't know, once every month or 2 months in my practice, angry HR director, angry CEO, angry founder, angry company owner who says, but I relied on ADP, I relied on paychecks, I relied on, I hate to call out certain number, it's just the reality. I probably shouldn't call out certain names, but I relied on these people to take care of this for me. And then when the problem comes up, they go back to their payroll processor or go back to their PEO, and the PEO says, well, we only use the information you provided to us, and we can only use what you provided to us, and we submitted it the way it was supposed to be, and they kind of wash themselves of the responsibility as well, leaving the business owner holding the short end of the stick, where they end up getting messed over because they thought that they could rely fully on the payroll processor or the PEO to comply with these things. So in front of you on the screen, if you have it in front of you, is just a form. This is ADP, but it's very standard. This is something I pulled off the internet of what a typical FLSA wage statement that would be produced in an FLSA type lawsuit looks like. And the way it looks is you have your regular rate of pay, you got the hours worked, and you have the pay periods and how that works out. And then this is, in this situation, this is an exempt employee, so you don't see overtime. If you can move to the next slide, I'm going to show you an example. This is a real world example, which I have scrubbed of all identifying information of a situation where, and this is very common, this is not unique, where someone got into trouble as a result of relying on in this case, ADP, but this is very common, and it's not ADP's fault. This is, they don't actually tell you they're going to do more than what they're going to do. But in this situation, for example, this is very common, and this is just one example where you have a salaried employee. And most employers think that if they have a salaried employee, they don't have to worry about overtime. Well, if you have a non-exempt salaried employee, you still have to pay overtime. And it's complicated in terms of how the overtime is meant to be calculated with respect to a salaried employee. The basic rule is going to be that if the employee is working more than 40 hours a week, you're going to have to pay them overtime for that time. So if you have a non-exempt employee who is working, you need to have them clock in and clock out. very often your PEO or your payroll processing company is not going to tell you that. They're not responsible for that. They should, right? And you should make sure that you are appropriately having every non-exempt employee clock in and clock out. Why? Because what often happens is you don't do that, and you have a salaried employee, and in this situation, the representative of the company didn't know any better, and they had a salaried employee, and they didn't have them clock in and clock out. They were paying them a certain amount every single month, every single week, and they reverse engineered those numbers into the payroll statement. And so while the person was earning a certain amount every 2 weeks in this situation, this period where it says this period 1777 every 2 weeks, working 80 hours plus overtime. Now, in reality, this employee didn't work overtime. This employee did not work 80 hours a week. This is not what happened. They weren't clocking in and clocking out. And so what often happens is the employer thinks, well, this is a salaried employee, and they just hand over to the payroll company 80 hours for 2 weeks. And this is their pay, which is, $1,800 every 2 weeks. And they plug it in and reverse engineer it, where they say, okay, it's 80 hours and their salary is $1,800, and it all seems good and well, until you have a plaintiff's attorney who looks at this document. Because if you look at this document, if you take away the overtime piece over there, the way this reads to a lawyer and to the Department of Labor and to a plaintiff's attorney is that this person worked a full 80-hour in 2 weeks, right? They were paid $1,800. Therefore, their rate of pay, you divide that out, was $22. The overtime rate of pay is now $33, and now you're going to be on the hook for the overtime over and above their salary, because you tried to reverse engineer what was a salaried position that was not clocking their time into an existing structure of the payroll document. So they just throw in there 80 hours, is what they work. Meanwhile, they maybe work 20 hours. They just don't care because they're a salaried employee. And so they don't really care how many hours are in there. They don't think it matters. But the way that reads in the document like this is that they worked a full 80 hours. And if there was not an overtime provision in here, what's going to often happen is they're going to say, well, you didn't have them clock in and clock out. The liability is on the employer to make sure that you keep the appropriate time records, and you didn't have them clock out for lunch. You didn't, and they worked through their lunch. So really they worked 45 hours a week, which is 90 hours in 2 weeks, which under the rate of pay at $22, and multiply that by 1.5, according to these records, again, pretend like the overtime piece is not there in this one. 1.5, that is the overtime that you're obligated to pay them. And you come back and say, what are you talking about? They're a salaried employee, they work less than 80 hours, and I just plugged this in. I plug and play because that's what I was told to do. I was told to report to them 80 hours a week because they're a salaried employee. Big mistake, because now you're going to be on the hook, because the records reflect that this is an employee working a full 80 hours. There's no record showing that they didn't clock out for lunch. So there's going to be an assumption, because it's not, the burden's on the employer, that they work 90 hours. There's going to be an assumption that the rate of pay is going to be the salary divided by the amount of hours worked. Multiply that by 1.5 for overtime. You're on the hook for overtime, even though in reality, this employee was smoking out back and not ever working a day in their life, right? And so this is and I'm not sure if I explained that clearly enough, but this is very, very, very common in terms of what we see, because the employer relied on, and then what happens is that they go back to the payroll processing company, to the PEO, and say, we need to fix these records. We've got to fix these records to reflect what really happened over here. And at that point, they can potentially get accused of tampering with the evidence after a lawsuit is filed and changing it, and it becomes a big mess. And then you end up with a nice, tens of thousands of dollars settlement, because you have no way of proving, because the records are not kept properly, no way of proving that this employee worked the way they did. And so this is the most common mistake. I see it literally every month in my practice. And again, where does this come from? This comes from the fact that the business owner is relying too much on the payroll processor, too much on the PEO to make sure that the information is being put into their payroll statements correctly. And it's your responsibility as an employer to keep track of time, give the payroll processor, the PEO, the appropriate hours worked and the time that's worked. Make sure that your rate of pay is correct in terms of what you're providing. Don't rely on the payroll processor to tell you what the rate of pay is. Make sure you calculate that appropriately, provide that to the payroll processor, make sure that the overtime is being done right, and check these records every single month and make sure that they're reflecting the appropriate flat rate, the appropriate overtime rate, and the appropriate hours. And if you're not doing that, I'm telling you right now, it's not a matter of if, it's a matter of when you're going to get a lawsuit or some sort of Department of Labor audit that you're not going to be able to defend. So that's the biggest cautionary tale that I've got practically of what you need to know, because at the end of the day, you're on the hook as a business owner, and be aware that the manager potentially can even be on the hook individually for wage and hour compliance. So be very, very careful around these issues, and make sure to talk openly with your PEO and payroll processor to make sure you're putting the right information, because the Fair Labor Standards Act does require records to be kept appropriately and puts the burden on the employer to make sure everything is right. All right, so I know I'm pretty passionate about that subject, but it just kills me when I see it time and time and time again, and it's so easy to fix. We can move to the next slide. Just really quickly, just be aware that different states, if you are working in different states, I imagine that the folks on this webcast are not as much, but different states have different laws that govern PEOs in terms of what needs to be in the contract, what kind of notice has to be given to employees with respect to relationships with PEOs, different registration requirements for the PEO itself. Just be aware that if you're working in different states, there are state requirements in some places for PEOs. Georgia itself does have some statutes around PEOs and defines a PEO as an employee leasing company who does do co-employment, pays the wages, has some level to direct the control of the employees. So Georgia does recognize statutorily PEOs in the way that we understand them, and assumes the responsibility for the withholding and payment of payroll taxes is going to be on the co-employer. And so be aware that in Georgia, there is some statutory recognition of PEOs in terms of who is the employer. But generally, if you're working in different states, make sure you're checking that state's requirements with respect to PEOs under state law, under state tax compliance, et cetera. All right. So what should you do in conclusion? When you're working with a PEO, make sure to review the agreement with your PEO very, very carefully. Make sure you are looking through at the indemnity provisions, that you know what they're taking responsibility, what they're not taking responsibility for. Make sure you understand what aspects of your HR compliance, your tax compliance, they are taking responsibility for, and let's make sure you understand what they're not taking responsibility. When in doubt, speak to the PEO, speak to the representative. There are some who I know who I think are on this webcast, and I'm sure they will tell you, I see Charlotte's here, that she will tell you, I'm sure, that speak to us. Let's talk this through, and let's have a conversation about what we do and what we don't do. Don't make assumptions when you're relating to a PEO, because there are so many different versions and colors of what a PEO might do and what might not do. Make sure you're talking openly with your sales rep or whatever representative you have there to understand what they're taking on, what they're not. Make sure you ask about the PEO's EPLI policy, their insurance policy, to see to what degree you're covered by that as a co-employer of that company. As I mentioned, check the indemnity provisions. When in doubt, speak to a lawyer, speak to the PBPA folks, and if you're there, to see if they can help you. But when in doubt, make sure that you are dealing with, you're setting up a proper relationship that works for you. Make sure that the PEO is certified by the IRS. And also, there is a National Association of Professional Employer Organizations and a licensing agency, the Employee Services Assurance Corporation. You can check and make sure that everybody you're dealing with. And again, if you're dealing with the big players, this is not going to be an issue. All they're going to deal with those kind of compliance issues. But make sure to check that they're abiding by the industry standards and are a well-respected and appropriate PEO to work for. But most importantly, once the arrangement's in place, just remember that you're in charge, and you have to make sure that you're doing things right in order to make sure that you don't end up in the pitfall of a thinking that the PEO is going to just absolve you of any responsibility for your legal liabilities. And when in doubt, with respect to the Fair Labor Standards Act, that is certainly something that you want to speak to an employment law specialist, a good HR person, to make sure that's being done right. And do not rely on your payroll processor or your PEO to make sure that's done correctly. So that's what I've got. I'm happy to answer any questions. Anyone is obviously welcome to reach out to me individually if they have any questions. My information is available on the slides, and you can get it also from the Pro Bono Partnership. And I appreciate everybody listening. It's not the most exciting topic on planet Earth, but I do think that it's a very, very important topic to know because it can minimize a lot of liability if you do it right.
Thank you so much, Josh. And I just wanted to mention that, it may not be the most exciting topic, but it's so important, and specifically for nonprofits, because when it comes to unpaid payroll taxes, members of the board of directors could be even personally liable. So this is an issue that should be top of mind for the nonprofit and for the directors who serve on their board. One question I had actually a couple questions that came through pre-registration. And one is about compliance issues affecting small businesses that have remote teams and locations outside the US. Do you have any thoughts for organizations that have individuals that are outside our borders?
Yes. Very much. It's a very, very good question, and it's becoming a bigger and bigger and more common issue. And I would add to that employers across the United States, because not to make a political statement, but as the country is diverging in terms of red states, blue states, in terms of their employment laws, New York, California, New Jersey versus Georgia, Tennessee, these kind of places. Georgia employers are not necessarily going to understand what their requirements are if they go hire someone remotely in New York, or if they go hire someone remotely in California. So it's not just international anymore. The country itself, the United States itself, states are diverging significantly in terms of the way they're handling employment compliance issues. And so the answer to your question is that obviously it's a case by case scenario depending on what country you're hiring in, and knowing what the compliance issues are within the country that you're hiring in. One easy way of getting around all the issues is looking into an EOR. As I mentioned before, when you're dealing with international employees, that you have flexibility. Even if you're only hiring 1 or 2 or 3 employees in various countries, that minimizes a lot of responsibility on you to figure out how you're going to do that. But if you are hiring people in foreign countries, you need to be aware of and cognizant of how that affects your U.S. tax withholdings and tax compliance in terms of what you're paying them. And it's a complicated issue, which I won't get into right now, as well as the tax and employment compliance in the countries where they're working from. From a practical standpoint, usually the country where they are is not going to have the arms to reach out and get you in the United States. And so often you don't have to worry as much about that. An example of this is going to be one I dealt with recently, independent contractors in South America or in the Middle East. It's becoming more and more common, or even Eastern Europe. If you're hiring folks out there, misclassifications with respect to independent contractors, if you do it in the United States, you're going to have all sorts of issues with respect to the appropriate W-2 versus 1099 classifications. If you hire outside the United States, sometimes you have less of an issue because it's unlikely that the local country is going to be able to get you if you're here. But generally, you are going to, if you want to comply with the law, you're going to have to be registered in the country where you're working. You're going to have some level of something to comply with the local laws. So I would say if you're planning on hiring people, even 1, 2, 3 people, and outsourcing actual employees in other countries, it is very worthwhile making sure you speak to either a EOR to help you with that, a PEO who understands, or even just an accountant who understands well enough international tax compliance when it comes to these issues, and certainly to an employment lawyer with respect to setting up your agreements to make sure you minimize your liabilities. Very common thing that occurs in those situations is going to be indemnity provisions and things involving non-disclosure of private information. I know this is not the subject of today, but just be aware of the fact that if you agree to your clients or you have any sort of NDAs with any people you work with, and then you go outsource some of that work out of the country, your NDA is probably going to have an indemnity provision, and you want to be careful to make sure that your confidentiality obligations are going to extend to those people outside the country. So there's a lot of things to think about, and if you're hiring outside the country, it's becoming more and more common. It's definitely worthwhile having a conversation with an HR consultant who understands international employment, to have a conversation potentially with an EOR or with an employment lawyer who understands these issues as well.
And my next question is related to the EFTPS. I believe that's the Employer Federal Tax something system. on the IRS website. Is that a good resource for nonprofits to use to kind of maybe follow up on what their payroll provider or PEO is supposed to be doing on their behalf with their filings?
Yeah, that's a good question, and the short answer is that I'm really not sure. Obviously, it's a good place to look, and it's always good to do your research. But I'm I'm not sure how much it's going to help. Short answer is I don't know.
Okay. Well, that might be another option for nonprofits to kind of just check up and make sure that those taxes are being paid as they are, as the payroll provider might be saying that they're paying them.
Correct. And it's definitely important to back check that.
We don't have any more questions today, Josh. I think that's it. Thank you so much for speaking with us on this incredibly important topic today.
It's a pleasure. And it's always a pleasure to be here and always a pleasure to be of help.
And for any of the nonprofits who were listening today who have questions on Josh's conversation today, feel free to reach out if you're a client of ours to PBPA. We can definitely help with questions related to wage and hour to make sure your exempt and non-exempt employees are properly classified. And to the nonprofits who have tuned in today or are watching the recording, we hope you found this information to be informative and helpful. Thank you for all you do in our communities.
And to the PEOs that might be listening, I'm sorry for raining on your parade, and I'll buy you a coffee or a beer. Thank you.
All right, y'all have a great day. Bye.